Hiya, my name is Elle de Koning and I'm the Senior Policy Lawyer and CLMI Implementation Officer at Ruah Legal Services. I'm here to talk to you about the new Criminal Law Mental Impairment Act and how it changed the law for people with mental impairment in our state. Effectively, since the year 1800, the laws around the Section 27 insanity defence and for people who are not fit to stand trial because of their mental impairment has not changed. Under WA's old 1996 Act, people who were not guilty because of the insanity defence, or what's known as the unsoundness of mind defence, or were never convicted because they were unfit to stand trial, were either unconditionally released or indefinitely detained. More often than not, indefinite detention of people with mental impairment occurs in a prison and not a health facility. For years, Australia has been the subject of international criticism for its treatment of forensic patients, including being internationally condemned by the United Nations. Let me give you some scenarios. Under the old Act, if a person was unfit to stand trial, they could face indefinite detention, even for a minor offence. These clients were never convicted of an offence. They were simply too unwell to participate in the court process. The evidence was never tested and never proven. This has been reformed by the introduction of special proceedings, which are tailored criminal trials to make it more accessible for unfit accused. Where a person was unfit to stand trial, the court only had two options: to either unconditionally release the person or place them on an indefinite custody order. This has been reformed by the introduction of community supervision orders, whereby the court can release the person into the community subject to conditions and supervision that they must adhere to. Under the old Act, the accused person's time in custody was not limited to the maximum sentence that could have been imposed. They often served well beyond that maximum sentence. This has been reformed by the introduction of limiting terms, meaning that we've set a maximum duration on the length of custody order. To learn more, head to ruahlegal.org.au.